Where we finished up last time was in instantaneous communication. So I want to basically head straight into the situation where we can't easily identify an offer and acceptance. Now, some of you might be grappling with a problem right now. Some of you might have solved it, where it's not easy to say which was the offer and which was the acceptance, and at what point did something that used to be an offer stop being an offer and start to be an acceptance or a counter offer or something else. And so it's really easy when we list out what the rules are. In order to have an agreement, we need an offer, and then that offer needs to be accepted, and we understand that an offer is a proposition to somebody to enter into a legally binding arrangement that is sufficiently certain so that we can understand what the consideration will be, or what the price will be is the term you can use for the moment, and that it will mature or ripen into a contract the minute it gets accepted. So we've kind of got this, I think of it as almost a biology thing. We've got this cell, this egg, for want of, let's be creationists. Let's not get into any feminist thought here, but let's just think of it as the egg. It's got absolutely everything it needs. It's got those double X chromosomes, you know, like as opposed to one of those broken Y ones, and then along comes a little sperm, and the sperm is acceptance. And the second that they meet, poof, we have this new life that is agreement. Now that sounds really simple in life, doesn't it? Just all you need is one egg and one sperm and we're fine. We happen to know in real life it's not that easy. That rarely is there ever only one sperm. It's a messy, messy business. I'm going to take this analogy way too far and somebody's going to complain, so I'm just going to stop right now. But in real life, it's not that simple. It's not A plus B equals C, or offer plus agreement, acceptance equals agreement. In real life, people go backwards and forwards all the time, and particularly in complex commercial negotiations. It's funny, I'm doing a project with a very large law firm at the moment around the usability of their documentation, and they went and got a design firm to give them some advice on what their font should be, like as you do. Anyway, long story short, the design firm came back with this bespoke font that really just screamed this firm's values and mission and everything. I'm kind of looking at it saying, yeah, but actually it's not going to be installed. You know, we reckon that 99% of the people we deal with use Microsoft Word. And this is not a Microsoft Word font, so we're going to have to do some stuff so it travels with the document. And actually every little extra buggy thing you do like that is more reason for it to break, and our lawyers are not really good at being tech support, so how about we pick something that's easy? And they're saying, oh no, don't worry about that. You just send your documents out as PDFs. Like, no, actually that's not how the commercial world works. That even though one law firm's name might be on the front of the document at the end of the day, actually what's happened is somebody's decided then, let's pick a transaction. Somebody's going to sell something. And so they negotiate with somebody about selling that thing, and they agree the broad terms, and then they might even write them down, they might have them in an email. Then one of them gets some lawyers to draw something up. And then a draft goes to the other set of lawyers, or maybe not even to the lawyers, to whoever's doing it. And they will fill in some gaps, and they'll change some things around, and they might say yes or no to something, and then it'll go back. And sure, the number of things that get discussed are really tiny, well, less and less each time. And when you get to an agreement at the end, the agreement presumably reflects the whole of the discussion. But you don't have to think very hard to know how things are going backwards and forwards there. It's really hard to work out. Like commercially, I think, yep, he offered to sell it to me. But at the end of the day, if I want to unpick and say which was the offer and which was the acceptance, much, much harder to do. And back in the olden days, when I was a girl and we used to actually print documents like that all the time, and people would turn up with their Mont Blanc fountain pens to sign things, quite often you would have two copies of the documents. They would have what's called, you will still see it regularly, a counterparts clause. The counterparts clause would say, this, amongst other things, it would also be an entire agreements clause that says everything that the parties have agreed is in this document, that supersedes any of their negotiations, and it's only becomes an agreement when both parties have signed. And then they would sit there and almost exactly at the same time they would sign. So technically whoever finished signing last was the one who accepted, and the other one made the offer. But, you know, they don't think about it that. They, like, you know, all of you have seen memes of Donald Trump with his big signature, you know, showing the signature. That's the moment that the thing becomes real. So what we're doing today, after looking at the theory and some of the cases that deal with how you work that out, we want to talk about what happens when it looks like an agreement. We know it's an agreement. We know the parties have agreed something, that there is a contract, but we can't identify an offer and an acceptance. We can only see the embryo. We can see the agreement. We can't see the individual components of it. So, sometimes, now, let's quick refresher, the mantra. What do we need in order to have a contract? We need agreement made up of offer and acceptance. We need consideration. We need certainty. And we need intention. And we're going to unpick what all of those things mean as we go. None of those things are document in writing. And I've just spent the last 5 minutes talking about a written document because a large part of commercial practice is that's what contracts are. But you can have a contract without having a single written document. In fact, you can have a contract, the terms of which are made up out of a string of correspondence. So the rules here are relatively clear. So basically, if you have a string of correspondence, we need to still be able to track through offer and acceptance. And again, if we can't, then we go to our next step, which we'll get to in a minute. Oh, sorry. I think that slide is just saying what I was going to say. If we've got correspondence together, oh, there it is. If we've got a string of correspondence, then provided that we can link each piece of correspondence to another, we can treat them all as one document or as one agreement. So as long as there is linkage that makes it very clear in the words that a previous document is encapsulated in this idea, then there is no issue with that. The case there is Air Great Lakes, and we'll talk about that more when we get to the formalities provision. Then we have this idea of the battle of the forms, and I think I mentioned this to you last week. This is where you've got people who are in a habit of being in business together. The example we've got here is a buyer places an order on its own forms that have its own purchase conditions and terms and conditions on them. Any of you work in an organisation that uses purchase orders? So on your purchase orders, do you have terms and conditions? Yeah. So basically, when you work there, you're going to buy photocopy paper, and you don't just go online to buy photocopy paper like the rest of us. You send out a purchase order. It's been approved by your finance department or, you know, accounts payable. That it will get paid provided it's on these terms. So you send that, take it off to Officeworks and hand it over, and then Officeworks will basically, most likely, give you the document, and they'll come back to you with their terms and conditions. And you might do that for years. And the two might be quite different from each other. They're unlikely to be entirely different from each other. But quite a common thing is purchase orders say, we'll pay you sometime within 90 days. And the actual contract note or the sales receipt will say, you need to pay us within 7 days. So there's usually, and that's a material term, quite a big difference. But people often just ignore that, it just goes backwards and forwards. So how do you work out what the terms are, what the contract is, if you don't have a clear offer and acceptance? One of the purposes of having an offer and acceptance is everything's encapsulated in the offer, and then it can be accepted. Where if we've got one offer and another offer, and then we kind of do a little bit of both, how do we work out what the agreement actually is? So these are called battles of the forms cases. The most famous of them is Butler Machine Tool Company case, and it is in your casebook. There, the erstwhile Lord Denning said, the better way to look at all the documents passing between the parties and glean from them or from the conduct of the parties whether they've reached agreement on all material points, even though there may be differences between the forms and conditions printed on the back of them. In other words, Denning is saying, actually, if it looks like agreement and it smells like an agreement, just because we can't find the two ingredients that we need to demonstrate an agreement, if objectively we can find an agreement, then maybe there's an agreement anyway. Now, this is often quite unsatisfactory to commercial people. Why would that be? Because you think, oh, that'd be good. I don't have to bother with offer and acceptance. Emily?
If they don't want to be bound by the agreement anymore?
If they don't want to be bound by the agreement. Well, particularly, what is the agreement if we use this? I know if my purchase order is the terms and conditions, I might be happy to be bound by it. But I'm not happy to be bound by your sales note. And I don't know if the contract isn't my purchase order and isn't your sales note, then what is it? Is it some of my terms, some of yours? How do we work out what that is? And really this is the test that Denning is saying that we need to use, is we need to actually recognise what it is that the parties are doing. Do you think maybe it'd be a good idea if I put some power on my computer, if that's the noise? Oh no, seems to be okay, sorry. Little aside, just don't like to run out of batteries in the middle of things. So, basically the test is quite clear. You have to ask yourself, is there an agreement? When and where would the offer and acceptance be? And if you can't find them, then you need to think about whether there is this manifestation and how you respond to the contradictions between the standard form contracts. I like to see, now Butler is helpful and it will give you answers to those questions, but I think that Justice Kirby's decision in Brambles probably helps us much more. And in his inimitable way, he has stepped out a process for us. So he says, in that case, where no offer and acceptance can be identified, it's relevant to ask whether an agreement can be inferred, whether mutual assent has been manifested, and whether a reasonable person in the position of each of the parties would think there was a concluded bargain. Whether a reasonable person in the position of those parties would think there was a concluded bargain. So we've got an objective test again. And what by their behaviour and their words. So it follows on from Butler Tools. So helpfully laid out a test. Look at the circumstances. Can you infer an agreement? Is there a mutual assent that has been manifested? Would a reasonable person conclude a bargain had been made? If you can demonstrate those elements, then even if you don't have a clear offer and a clear acceptance, you can achieve agreement. Now this sometimes means looking at the conduct of the parties after the point in time when so-called agreement was in fact made. You need to understand how the parties acted and dealt with each other moving forward. So a framework for determining agreement might look like this. Start by identifying a distinct offer and acceptance in accordance with the conventional approach. Because if you can find an offer and acceptance, you don't have to bother with being able to deal with the rest of this, and you also don't need to identify what the terms of that contract might be. And we'll talk a lot more about what the terms might be in the second half of the semester. So if that fails, then the next step is to apply the Brambles test, look at all the circumstances, see whether an agreement can be inferred, whether there is mutual assent, and whether a reasonable person would find a concluded bargain. So if you're going to apply a test like that, you're going to need to pull out each of the elements, and you're going to need to point to the facts that support that finding. Questions, concerns, frustrations?
I think reasonable person view could be a very subjective despite itself.
I think that's a really interesting point. A reasonable person's view might in fact be quite subjective. I'll just, Tao, what would you like to say?
So my question is regarding the Brambles case regarding for the service provider.
Can we go back then? Can I come back to you? Because I'd like to just discuss Kin's point for a minute, and I just guessed you were going there. No, that's okay. It's I think that it's an important point that we should think about. So how do we know what a reasonable person is? Until relatively recently, pretty much every judge who was making that decision was a white guy in his 60s. Most of them went to private schools. They definitely, until the judges who are around at the moment, went to the Ivy League law schools, no doubt about it, because the rest of these schools weren't around in time for them to do it. What they think is reasonable might be quite different from what I think is reasonable, or what you think is reasonable. How do we deal with that?
Isn't a reasonable person defined as your average person that you meet on the street?
The question is, well, how do you define a reasonable person? And so TAPS is saying, well, isn't the definition, I think there is a definition that comes from one of the cases that I can't remember at the moment. It's like the man on the Clapham omnibus. So, and effectively that's what the courts have been trying to do, and they will take evidence as to what might be thought by these things, because they're trying to put themselves objectively into the position of the people having that knowledge. So what is reasonable for two carriers of, or two sets of stevedores who are squabbling over the way that carriage works between island nations is probably quite different from what's reasonable between the owner of a gym and a person who signs up for a gym membership. They're different people in different circumstances. But again, there's a lot of risk. Commercially, there is a lot of risk in trying to, if you're relying on ultimately a court will unravel this, you are not doing your job properly as a legal person or as a commercial person. I was talking to somebody this week and I was saying that one of the issues in relation to negotiations that comes out a lot, it just drives you crazy as a lawyer, is when you're dealing with very aggressive negotiators who, in a team, and they'll say, those people who, when something's on the, they'll show their might on the table and they say, oh, if we don't get this, we're walking away. They're effectively making a counter-offer that means that whatever's on the table at that point is extinguished. So if the other party want to walk away at that point, you've given them, they've got absolutely, there's nothing you can accept once you've made that counter-offer. And trying to convince robust and aggressive negotiators that they can do that is very, or that they shouldn't be doing that is a very difficult thing to do. Questions, concern? I'll come back to Tao's question, but just on that point about what's reasonable.
I think the judge is reasonable person is only for people who have studied law, because a lot of people don't even study law. How can it be reasonable in terms of that?
So how can you be reasonable if you hadn't studied law? My husband would say, how can you be reasonable if you have studied law? You're just going to win every fight. But look, I think it is something that is hard to get your head around. And it's a jurisprudential issue at one level, and it requires a level of faith in the system that some of us might be a little bit more circumspect about. Ryan, did you want to comment on that, or have you got a different question?
Not that specific, but Brambles Test.
Okay, I'll come back to Tao's question on Brambles now.
So my question is regarding for the judge used come to different channel to reach a conclusion. Firstly, he said the Brambles did not reach a contract because of failing condition, and later on, probably in the paragraph, very end paragraph, said you can infer because of gains and benefits. So really comes about benefit detriment consideration.
Yeah, there are more points on the consideration point, absolutely.
So my question regarding this is the service provider cases, but like not only for the short sale cases, really do not kind of identify the benefit and detriment. So how can we infer?
Well, let's hold that because we'll talk about consideration. And in just a straight sale in a shop situation, we're not talking about these multi-layered different documents and inconsistent documents. We're just talking about a contract where you take something off a shelf and you basically make an offer for it. But there is a benefit and there is a detriment. Again, consideration needs to be sufficient, it doesn't need to be adequate. So we will talk about how those things fit together. Sorry, I keep putting you off, don't I? You see, he asked tricky questions, I just want to answer them later. Ryan, your question.
I just want to ask, with the reasonable person's view, that's a third person, right? That's a hypothetical third person.
Yeah.
So just looking at both, like if you saw two people, it's not like, oh, well, such and such thought there was a...
No, well, see, yeah, you're using this objective test as opposed to a subjective test. So it doesn't matter what the manager at Brambles actually thought. What matters is what a reasonable person doing their job, having the same information as them, would think. And remember that the information that they have is limited to whatever information might be admissible in the court anyway. So we're not asking you, we're never going to ask a witness, what did you think was going on here? We're asking for evidence of what the situation was so we can work out what a reasonable person doing that job in that situation would have. You have to remind me of your name. Subi.
Yeah. How often do you come to the situation where you have to test the reasonable?
Really good question. How often does this actually happen? Easiest way to have a look would be go into something like Jade, which cites quite regularly, and look for, cites quite efficiently, and look for this Brambles test and see where it's been cited, see how often. I think you'll probably find quite a lot. The reality is much, much less often than these kind of contracts happen because no lawyer of any repute wants their client fighting out whether there was a contract or not in this situation because there's too little control. Okay, there is too little control over the situation. Going to court is a very messy, nasty business. Particularly, you really wouldn't want these in court now where you could mediate or arbitrate them and do it off the public record because as soon as you have this fight with one of your suppliers or one of your customers, then and you lose, every other customer knows about it, okay? So it's all actually in the open. So what I know, you're studying law, we're going to talk about the legal principles, you have to do that, but we have to, as much as we can, try and think about how they work in the real world. Okay, I know I'm going to be a little bit quick with your questions today because there's so many of you and we do need to get through. So, these are the kinds of questions that we've been dealing with. I'm really going to stop at this point and not go through too much detail. These slides have some of the key takeaways on them if you go back and have a look at them. But these are the kinds of questions that come up. And when you're thinking about, is there an issue I need to think about, these kind of points are the points that you should be thinking, can I identify an offer in this situation? Could it be that there's a unilateral contract here? Maybe it's not a bilateral contract, and so maybe I don't need to have two sets of obligations after the point of time that the contract is made. That will make more sense to you as a question when we talk about consideration. Being able to identify the different stages in the journey towards a contract and understand how just because something is something at one point, would be categorised in one way in one point, how it gets reacted to could reclassify it. So something that's an offer ceases to be an offer at the point in time where in the sense that it lapses, and the point in time when a counter offer is made. So, and sometimes the language, because commercial people don't get the language right, you have to really think about it. I was just marking some late exams, and there was like a set of short questions, and one of them was asking what a conditional acceptance was. Conditional acceptance. Anybody here want to tell me what they think a conditional acceptance is? Can you define it? Yeah, it's a counter-offer. It's a counter-offer. Well, a partial acceptance would be a counter-offer too. Okay, so, and it's funny, somebody's written 3 pages on the law of conditional acceptances, and I'm pretty sure they pulled it came from the Paduma Institute. Have you heard of that? Pulled it directly out of my arse. I'm the CEO of the Paduma Institute. So think about these things and you do exactly what Joe just did. Don't be thrown by the words, okay? Just sit back and think, okay, well, what I know about acceptance, I know about agreement, I know about offer. I'm not going to get skittled by it being called something else. And, you know, if you've done the work, you won't walk into an exam and think, oh, here's a term I've never heard of before. Or if you do, you will pick up your dictionary and you will look it up. And you'll find that it's not a term there, or it will actually point you to counter-offer or whatever it does. I don't know, I don't have the same dictionary as you. But you know, you'll work it out. I mean, you've got to trust yourself a little bit here. Okay, I'm going to stop the recording now.